Good afternoon, everyone, and welcome to day 2 of the 10th Annual Georgetown International Arbitration Month. Today is the Future of Arbitration Day, and we have 2 fantastic panels lined up for you. We begin with the first panel, Is the Future of Arbitration Greener? We have experts in the field lined up to speak to us about why it's important to think about green arbitration and how arbitration and arbitration-related events can be made sustainable and environment-friendly. I will briefly introduce our esteemed panelists now. We have with us Annette Magnusson. Annette is the co-founder of Climate Change Council. Annette's focus is leadership, innovation, and policy advocacy. She works with clients in matters relating to a systemic change through research and trainings, and is engaged in high-level dialogues with managements to foster change. Before Climate Change Council, she was the Secretary General of the Arbitration Institute of the Stockholm Chamber of Commerce. She has more than 20 years of experience in international law, including from global law firms, and she's the founder of the crowdsourcing initiative Stockholm Treaty Lab. Thank you so much for joining us today, Annette. We also have with us Ryan Hicks today. Ryan works in the dispute resolution group at Freshfields Bruckhaus Derringer in New York. Ryan is the secretary to the Campaign for Greener Arbitrations North America Committee. Before joining Freshfields, Ryan was an award-winning journalist with the Canadian Broadcasting Corporation, which is Canada's largest broadcaster, where he covered politics and breaking news. He produced original and investigative journalism as well. In 2019, Ryan received the Amnesty International Media Award for his on-ground reporting from Guatemala about the root causes of migration to the US southern border. Thank you so much for joining us today, Ryan.
Thank you.
Our next panelist today is Cherine Foty. Cherine is a senior associate in the International Arbitration Group of Covington and Burling in Washington, D.C. She is dual qualified in common law and civil law, and she spent several years practicing international arbitration in the Paris office of a major US law firm. Cherine practices international commercial as well as investor state arbitration, and she has experience with a broad range of arbitral rules as well as applicable laws. Cherine is the co-chair of the Africa subcommittee of the Campaign for Greener Arbitrations, and she's also on the board of directors for Arbitral Women. Thank you so much, Cherine, for joining us today.
Thank you so much. Just sorry, one correction to the to my bio is that I'm no longer sitting as the co-chair of the Africa subcommittee, but I am the vice president of the global subcommittee, but of the global steering committee of the campaign, but still very much involved in the Africa subcommittee. So thank you.
Thank you so much, Cherine. That's fantastic. Thanks for letting us know. This panel today will be moderated by the treasurer of Georgetown International Arbitration Society, Patrick McManus. I'll just briefly tell you about the format. It will comprise of a 45-minute moderated discussion, followed by 15 minutes of question and answer from the audience. Following this, we'll have a brief networking session with our panelists. And for that, our audience will be assigned into breakout rooms with the panelists. I will request everyone to shut their cameras and mute their mics until the question and answer session. They can, of course, turn on their cameras for the breakout room networking sessions as well. Thank you all once again for joining us for what promises to be a very interesting and insightful panel. We would also like to thank our sponsors and supporting organizations for making this event possible today. I will now give the floor to Patrick to begin the session.
Hi, yeah, thank you so much. I'd like to also extend my thanks to the panelists for spending their time with us here today, and welcome the audience and encourage everyone to think about what questions they might want to ask at the end. So jumping right in, I think I'd like to give each of the panelists an opportunity to give any introductory or framing remarks that they have regarding this topic, and to address the question, why is it important to think about environmental sustainability in the arbitration context, which I think is a fair question, because when one, sort of imagining, threats to the environment, you think of, coal-fired power plants and freeways clogged with cars, and not necessarily lawyers in their offices doing their jobs. So I think, framing the conversation around that might be helpful. So Annette, if you'd like to start.
Yes, I would be happy to start saying thank you very much, Patrick, and hello everyone. Thank you very much for having me here for this discussion here today. And I'm very pleased to be able to talk to students this afternoon because indeed this is the future of not only arbitration but sort of society as we know it going forward. I think one should keep in mind that international arbitration is a reflection of the society in which it operates. So whatever sort of happens and whatever the trends and developments you see in society at large, or you need to see, is also something that you could reflect and see in international arbitration. And I think climate change mitigation and adaptation measures is no different. So I think whenever there is an opportunity to put those green glasses on in your practice, one should take that opportunity. And that could be all over sort of when it comes to the substantive issues or when it comes to sort of practical issues involved in the arbitration. Always keep in mind that what is the footprint that we are creating by this activity that we are doing. And I think we'll come back to this in the discussion later, and sort of how you can find ways into turning those ambitions into actually obligations. That's what we like as lawyers, because that's when you get something really to bite, right? So and have a conversation around that. But I do think one should just keep in mind that international arbitration is not working in isolation. It is very much connected to the world around it, and should be to do its job properly. That would be. And if I wanted to add one more thing, I think also that we should not forget that climate or environmental issues is not also isolated to one particular practice or one particular practice group, for example. So I think probably the single most valuable thing all of the students joining here today could do as they sort of move into their own practice is to really always, and that I mean this really always, to keep that low carbon perspective in mind, regardless of what kind of practice you enter into, because there are opportunities and there are ways to reduce emissions and have a low carbon perspective in regardless of what kind of practice group you're active in. So I think that's something also that is very important to keep in mind. So I'll stop there.
Great, thank you. Ryan, if you'd like to share your thoughts.
Yes, thanks, Patrick. Thanks, Patrick and Bhavana, for the invitation. And it's a real pleasure to be on this panel with Annette and Cherine. So thank you so much for this. I think, echoing a bit of the sentiment of Annette's remarks, we are in a climate emergency and everyone needs to reduce their carbon footprint. So we all need to kind of operate from that default, right? And in arbitration, that applies to arbitration in particular because international arbitration, by its name, has historically involved a lot of flights, a lot of, before the pandemic, unnecessary travel. And I think that post or after the beginning of the pandemic, it's forced the practice of international arbitration to really reflect on the carbon footprint because we could not travel. And I know when talking to people, when talking to partners, for example, even at my firm, they say to me, the days of flying around the world for a 1-hour meeting with a client, those are over. Both from the client perspective and from our perspective, the clients and the firm, number one, there's the cost consideration that people are more attuned to now, but also, and very much like on an equal plane, I would say the carbon footprint factor. And so I think, it has applied to international arbitration in those ways. That pre-pandemic conference and training circuit was very active with many gatherings around the world. I remember people telling me about going to back-to-back, conferences, all around the world and doing these huge transatlantic flights and saying, oh yeah, hey, I'll see you at the next, conference tomorrow in Madrid. And they were in, Singapore. And so I think what's happening now is, now that we have as a practice pivoted to a more environmentally friendly way, or we're starting to be more environmentally friendly. We're starting to really be conscious of our carbon footprint. We want to avoid falling back into those bad habits that we maybe had as a practice area. And that's why the Campaign for Greener Arbitrations North America Committee held a workshop. We held this workshop back in October talking about shaping the future of greener international arbitration conferences and trainings, so we could harness all of the learnings since the beginning of the pandemic in terms of best practices when it comes to holding a virtual or hybrid conference and training, and sharing that within the community so we can kind of keep that momentum going forward.
Great, thank you. Cherine?
Yes, thank you so much, Patrick, and to Bhavana as well, and Rebecca for their organization of this event. Delighted to be here. Today I have my hat on as the vice president of the campaign's global steering committee, and maybe I'll just share a couple of words about the campaign itself, just so everyone is aware what it's about. So the campaign was actually founded in 2019 by an arbitrator, Lucy Greenwood, who had the commitment to conduct her arbitrator and counsel practice in a more sustainable manner. So she herself made deal with her practice in a more sustainable manner, reduce flying on flights, cut down paper as much as possible, try to use green energy in her practice, and just promote those sustainable behaviors across the board with the different actors she was involved with. That caught on and was quite attractive to a lot of other people in the practice who quickly signed on to her Green Pledge. And now we have a full-fledged global initiative, which has touched in regions all over the world. We now have actually 6, and moving with our newly inaugurated Caribbean subcommittee, we now have 7 regional committees across the world. We have subject matter committees that are dealing with various aspects of how to promote sustainability in arbitration. And we have around the 10-person global steering committee who's really thinking very strategically about how do we address this issue and have the most impact within the profession. We also have very close alliances with other initiatives. There's the Greener Litigation Pledge, the Green Mediation Pledge. There are a number of other elements within the practice of law more generally that are committed to these objectives. And the general objective of the campaign is to reduce the environmental impact of arbitrations by promoting awareness and best practices within our practice. We have most recently launched about a year ago now a set of green protocols, and I can discuss that further in the discussion, but they are, tools which can be used to actually implement a lot of what we're talking about. So I'll leave it at that to keep it short, but let's happy to discuss further in the discussion.
Great, thank you. And I think that's a perfect segue to the next sort of piece of the discussion, which is, if I was coming into this conversation skeptical about, how much we need to think about the environment in the arbitration process, now I'm convinced, but now I'm wondering, what can we actually do? And, when we think about our obligations to clients and what the job actually is, how do you decide, what can be done on Zoom when a flight actually is necessary? So maybe, Cherine, if we can stay with you and just jump right into thinking about what that looks like.
Sure. So I just wrapped up a hearing, which was a virtual hearing with a hybrid element in the sense that our side got together. So the client, the experts, the witnesses, we were physically present in the same place, despite some discussion of whether we might do that fully virtually. So this is always going to be, I think, a pushback you get in practice. How do you actually implement a fully virtual proceeding, without the need to be together in person? We were able to successfully do parts of it virtually, but, as you go through and as we move the practice towards that, conception of not needing to travel at all, there's of course going to be some resistance, and you have to assess that from a kind of client representation perspective. But one thing we were able to do was to ensure that we weren't producing unnecessary waste. So we didn't have a full case file printed for consultation on site. And despite the suggestion that that should be done. And, you know, that necessitated some pushback, and you need to, I think, as various members committed to this, we need to raise it when possible within our teams, and raise that to the client, because sometimes people just don't have it on their radar at all. And I was happy that we were able to dispense with that particular requirement, although we weren't able to do it across the board for all printed materials. So one thing I took away from this latest hearing is really the need to instill early on in the proceedings a very clear kind of default status quo of operation, which takes into account sustainable measures. And that's something that we propose in our Green Protocol for Arbitration Proceedings, which includes a model green procedural order. So a typical kind of procedural order one that would typically be adopted at the start of an arbitration proceeding, in which the default commitment is to conducting the proceeding in a sustainable manner. So default for electronic submissions, default for, you know, not printing or not sending USB keys and printouts of submissions, you know, on DHL overnight across the world, not you know, sourcing your catering and you know, other aspects of just logistics in a green manner that that use service providers that operate either on green energy or with green packaging, or, you know, all of these different elements. There are very clear kind of minute distinctions and suggestions that are included in those protocols, which encourage that type of behavior. And as I mentioned, adopting that early on can really save the discussion later on. It can just set the stage for how the entire proceeding is conducted, and it can really cut down on waste. Later on, you might not have as much success kind of changing the default position, whereas early on, if that's set by arbitrators or proposed by counsel or agreed upon between counsel or even promoted by a client, you would have much more success of achieving those measures. So those are just some thoughts on that question.
Great, thank you. That's a lot to think about, definitely. Annette, do you have anything to add to that sort of a position?
No, I do think it's important to be proactive and bring these issues up early, and that's why I think the protocols are very well suited to do that. And then I also think they do set a standard, and it's fantastic that the community has now come to this, that we have these instruments in place. So it's nothing controversial, in my mind, to bring these proposals up. They should be sort of a given, right? So, and we may take that for granted now, but you go back 10 years and that was not the case, and it was probably just as urgent then as it is now. So we are moving in the right direction. I do think when we're talking about sort of the impact of international disputes, when we go back to sort of the bigger picture of emissions, we need to always keep in mind, though, that what we're talking about here is sort of a fairly limited share of the emissions. So one should always keep in mind sort of the bigger picture in terms of what is the underlying transaction or the underlying dispute or the underlying issues involved in advising the client, and what is the carbon footprint of that. And that's something that is equally, if not even more important to keep in mind. That obviously goes beyond the actual procedure, but again, I think one needs to have that perspective as well embedded in what we do.
Yeah, great. Ryan, would you like to chime in?
Yeah, I'll just add a couple of things. I thinking about a bit about what Cherine said, and she was referring to the model procedural order. That's a lot about setting the tone from the top as well as from the beginning, because that way you have the members of the tribunal on board, the most senior lawyers on both sides, on board, and then that filters down. But then we also have to remember, and especially for law students, as you eventually get into practice and get into a law firm, it's important for that to also come from below, right? Because if you're more on the ground level of a case, you might see some things differently just because you have a different perspective because of where you are in the chain. And so it's about, feeling comfortable, raising, okay, have we thought about, doing this in this way that might be a bit greener? I think it's also really important because clients are thinking about this. This is something, as a law firm, Freshfields, we are looking at service providers who will offset their carbon footprint or have green practices. But that means that clients that we are working with, that they're looking to us for that as well. So we need to practice what we preach. So I think those are some things to keep in mind as well.
Great, thank you. I think that transitions nicely to the idea of who in the process is best suited to set the agenda in terms of thinking about the environment and sustainability. Like, should it be coming from lawyers or if it's something clients want, obviously it's something that we can be working on, but to clients maybe who aren't as conscious of that, how much of a role can arbitrators play in sort of pushing them towards that, or is it more of a job for institutions and outside organizations? So Ryan, if you want to just stay with.
Yeah, at a broad level, it's all the stakeholders in the arbitration community that need to think about this and have a role to play. And so when we're talking about all of the stakeholders, who do we mean? We mean the users of arbitration, correct? So the clients, the people in the dispute. We're talking about the institutions. We're talking about the practitioners, the organizations, the client coordinators, the administrative staff, the paralegals. Everybody has a role to play, and the campaign for Greener Arbitrations Green Pledge was launched because everyone can do their part at an individual level, and everyone on the team should really have this in mind. And like I mentioned before, the junior people they're often very close to the case, so they might be able to identify different opportunities than someone more senior, and vice versa. And also, going down to the administrative staff as well, who are key supports in this. And when pitching, from a business development perspective, I alluded to this earlier. Featuring your firm's green credentials is important because many clients and potential clients are looking for that in a firm.
Great, Annette.
Thanks. So so many things coming up in my mind here, but I do think it's as Ryan said, all of the stakeholders really have a role to play here, and I think all the stakeholders will have different tools on how to play that role. Now, I come most recently from sort of the institutional side of international arbitration, and I do think institutions have some very interesting tools here to sort of embed this perspective in their procedures. That could be either in the rules, or it could be in their sort of different guidelines that they publish on how things should be done under their rules, if they can't embed these things in their rules. I mean, we did simple things at the SEC, like in the arbitrators guidelines, we specifically stated that when you did any carbon offsets as an arbitrator, if you had to travel, then that could be included in your sort of request for remuneration of costs, for example, in the procedure. I mean, that might seem like a small thing, but you put bits and pieces in here and there, and then it adds up. And of course, adding to this again, I have returned to the protocols, but you can build that into whatever recommendations you're giving your users, including your arbitrators. And I want to also say a few things when it comes to sort of the importance of the younger voices, which has been sort of alluded to, because I do think it's extremely important. And I mean, let's be honest, if you look at the traditional law firm, it's sort of the pyramid, right? So it's the bottom of the pyramid might not always have the strongest voice, for example, in the practice group, sort of the most junior members of that team. But here you have a situation where it actually could be the other way around, because the most junior members will probably be more, and this is me speaking from a prejudice, but also to some extent actually to experience, will be more connected to what's actually happening in terms of innovation and expectations on values, right, to be represented. So you bring that into your group, because the clients certainly will expect, and Ryan was talking about, right, you need to align with your clients' expectations and your clients, the demands on your clients, you will be able to meet that. So I think here there's a really good opportunity for young voices to come in and really to take lead together with the senior partners, maybe to an extent that you do not see in other traditional questions in when you're working on matters, to bring that perspective in, because it will in the end mean that we might do things differently in terms of working with the clients, and have different conversations with the clients, and different choices to be made, strategic choices to be made with the clients. And again, I do think that the younger generation are extremely well equipped to take a seat at the table in these conversations.
Great, yeah, I think that makes a lot of sense, and is definitely encouraging as a young person thinking about these issues. Cherine?
Yeah, so thank you. I want to capitalize on what both Annette and Ryan said, and particularly reference the green protocols here, because I think they do, I mean, they were both alluded to by both speakers just before, but they do address each of the particular stakeholders. So the actors in arbitration are particularly targeted by each protocol. And we did that deliberately. I had the pleasure of being on the drafting committee for those protocols. And we initially had a single protocol, but then we thought it could be much more effective to tailor each protocol to the particular actor who's dealing with the arbitration. So we have one for arbitrators, one for institutions, one for counsel, and then one for service providers and conference organizers, as many other people kind of lumped into that one. And the idea there is that each person has their particular part to play, but they look at these issues from a slightly different perspective. So, when you're an arbitrator, what your primary concern is, having all of the materials so that you can be able to properly assess the case, being able to have ease of access, be able to get through the file as simply as possible, have the right tools necessary to be able to make your decisions, and not have kind of your decision-making capacity impacted somehow by the organization of what you're accessing, what you're assessing, right? I think that's maybe a little bit too simplistic, but it's one of the main considerations. Counsel, of course, have a different perspective in that they want to get, of course, their client's case across as convincingly as possible, and they don't want to sacrifice kind of the importance of their client's case by changing certain things around to necessarily be more sustainable. And I think institutions similarly want to make sure that they're managing their cases in a particular way. So in setting forth these protocols, we took very careful, we considered very carefully the importance of maintaining and preserving the importance of arbitration and the importance of the client representation and resolution of the dispute elements of arbitration, while at the same time incorporating the sustainable elements. So each protocol takes that into account in a very particular way while preserving due process rights and while ensuring adequate representation. So the idea is that it's not supposed to displace those primary objectives of arbitration, but rather complement them, and even arguably, and I think this is certainly true from my perspective, enhance the ability to be able to perform those objectives, and even serve the possibility of engaging in cost-cutting measures that clients find quite attractive. So I think that's an entirely separate topic, which we can talk about further, maybe in some of the subsequent questions. But each player, in my mind, really has a key role to play and needs to look at this issue kind of from one side of a sphere where everyone kind of contributes their important perspective to a holistic issue.
Yeah, that's really interesting to think about. But thinking about a follow-up question, which is a lot of the people in the audience here are law students. And so as we're sort of, learning the law, thinking about what kind of role we might one day end up in, what are the skills, I guess, we should be sort of developing now that will be translatable? Like, for instance, I know some people who, really hate doing readings online and will print everything out. So, I mean, if they're really uncomfortable with that, and now is this the time to address that, or are there other issues?
So yeah, I think it's absolutely the time now to start bringing these practices into your life and your practice as future lawyers. I mean, I'm also someone who had the default of printing at least the most crucial documents out and highlighting and kind of writing my notes, and that kind of activity was, for me, an essential part of my assessment of a case and really understanding the issues. What I've found is that you can replicate those that function by using particular tools. And one of the elements of what the campaign is engaged in is trying to provide really key key suggestions and key practices that can be easily adopted that really replicate those behaviors in a way that's sustainable. So one way you could, for instance, mark up something that's not necessarily paper is to either have an iPad with like a pen, an electronic pen, or you could, you have particular software that allow you to annotate PDF documents, highlight them, put like particular notes in the margins. And I would argue sometimes that's even more practical than actually having a hard copy. You can't necessarily sift through it page to page, but what's really useful about it is that you can, word search. You can, if there's something, some particular note that you have highlighted, you can find it in multiple places. You can color code. You can do all the things you do with, with highlighters and pens, and then you just stock it in a place where you actually know where it is and it doesn't get lost, and you don't have, a million Post-its all over the place trying to figure out what you tried to know earlier in your review. So that's just one example, but I think that a number of our behaviors as lawyers can be replicated in a sustainable way. And so engaging in those practices now while you're in law school, I think is certainly encouraged and will lead to a more sustainable practice as a lawyer. I just remember in law school, seeing the Westlaw and Lexis rooms with all the cases being printed out and thinking, this is just such a waste of paper, really. And if you have the opportunity to be able to mark things up yourself electronically, I think that saves quite a bit.
Yeah, personally, I'm a big fan of Control F and highlighting things with different colors on the computer. But Ryan, do you have thoughts on skills law students can be developing?
Yeah, I would. I agree 100% with what Cherine is saying, and I think, especially in arbitration, arbitral decisions and memorials can be some of the longest ones in the whole dispute resolution field. So that's another way that maybe arbitration is a little bit different. There's these hundreds of pages of briefs going back and forth, and I think what Cherine said about building in those habits and using the tools and using the technology. One thing you have to keep in mind is that when you go to a law firm and when you're going to the workplace, you will want to be able to articulate okay, this is why if you notice that maybe people aren't using an iPad that much, at least for yourself, you could ask your IT people, I would like to get an iPad because I would like to have a green practice, and it's part of my commitment, not to print things, and really just like finding the words and the language. And I think people are more receptive to that now. I know for a recent hearing that we were preparing for, the partner on the case was only using an iPad for all of the bundles and all of the documents, and would be working on her laptop for what she needed to work on for the laptop. And then when she needed to refer to the bundle, she was looking at the iPad. So I think, I echo 100% what Cherine said. And I think even to take it one step further, it's having the confidence and having the words to express, once you get into the workplace, if those resources aren't being, offered to you proactively by the firm, you being proactive and and putting in that request with what I think is a a strong justification.
Yeah, excellent. Annette?
I think the key word here is proactive. So I completely agree that sort of asking for the tools that are the modern tools, if you do not have access to them immediately and get acquainted with them now, I'm thinking most people on this call know much more than me on sort of the tools out there in terms of electronic ways of working. So I don't think that will be an issue to be acquainted with the tools, but just to make sure that when you do enter your first workplace that they are there, and if they're not, you should ask for them. Having said that, I think also one should look for sort of a balance, because it's not a binary game in terms of everything printed is bad and everything digital is good, right? So we just need to find that balance. And then I will probably, until the end I stop working, I will continue printing things, right? Because there are moments when I work where I just realize that this is the most efficient way for me to get this done and to get the sort of in the shortest time period possible, get the highest quality possible. For different reasons, I need to print these pages. So, but it's having said that, of course, it's better to do it 1 time out of 10 than 10 times out of 10, right? So just to keep that sort of, it's not a binary 0 or nothing. It's, find your balance and try to navigate that and use the tools to the best extent possible. And again, I think we need to also see the bigger picture, that the practice of how the tools that we are using and also the matters we're working on, and sort of what is the substantive issues there. I mean, if you in your practice if you're able to enable a fossil fuel steel plant to be built, right? Well, you know what? You can print your papers, because you have achieved so much just by doing that for the greater good of this planet. That's okay if you print a few pages. So I'm just saying this, we need to sort of, you need to look at the bigger picture in everything that we do, big and small.
Yeah, I think that's a great opportunity to transition a little bit from talking about the process to the substance of arbitration. And is there more of a way that, well, I guess this is still a process, but is there a way that the process can favor outcomes that are more environmentally friendly versus just being done in a way that that is more sustainable? And what does that look like? Or, is it possible, I guess?
Is that for me, or are you?
Sorry. Yeah, if you have thoughts, please.
No, I mean, you can look at that question, of course, from both the procedural side and of substantive issues, right? I mean, we have talked about the procedure, and I think the flexibility of international arbitration is brilliant when it comes to adopting the procedure to the needs of the modern world, and that those needs now being represented by having us the low carbon footprint and sort of take the measures you need to move your procedure online and to put those protocols in place and to have the procedural orders to say we will not have bundles printed, we will have them on the electronic form and so forth. All of these things that the tools that you have and the flexibility you have in international arbitration makes the process very well geared towards sort of meeting the immediate needs, right? If you are in a state court setting, that's a slower process to adopt the procedure if you need to adopt it to sort of meet these needs. So I do think the international arbitration is very well suited to be sort of hit the ground running, so to speak, on that note. When it comes to sort of substantive issues, there is, I mean, there are situations, I think, when international arbitration also could be very well serve the low carbon or the lower emissions or the energy transition purposes. For the same reasons, I think that international arbitration is a very good procedure to begin with. So you have the flexibility, you have the expertise that you can appoint in the arbitrators, you have the experts that you can bring in, and again, you can gear the procedure to meet the specific needs of the substantive issues that you have before you, and that could well serve the green perspectives that you could see on the substantive issues aside. So I think the general advantages of international arbitration in a commercial context are as present in a climate change setting as they would be in other settings, right? Those general advantages can work and be used in this setting as well. Now, of course, there are substantive issues that will be difficult to bring to arbitration for the mere fact that you need to have an agreement between the parties. So many of the issues that we are now see being heard in courts around the world, the climate change litigation issues, will be difficult, if not impossible, to see in an arbitration setting. But so I think they complement one another in bringing the climate change issues into a legal setting and make ambitions into obligations. And just before I conclude, I think what we probably will see, which I hope we will see more in the future when it comes to international arbitration, we will see more of the green contracts being subject to arbitration. So I hope we will be seeing more and more the green ambitions being built into the general commercial contracts, the general commercial practice of lawyers. You should have those green glasses on. You should have those low carbon glasses on when you're drafting your agreements, when you're setting up your deals, when you're doing your transactions. You can build those perspectives into your legal framework. So if that is being done, now clearly, as we know, a certain percentage of all deals being struck will end up in a dispute. That's just sort of a matter of life. And so when they do, we will see more of those in international arbitration, and that will require a certain amount of expertise on how, for example, low emissions clauses should be interpreted. But again, arbitration is very well suited to meet those needs because we do have the ability to appoint those specific experts that are needed for the case at hand.
Great, thank you. Cherine, do you have a view on the relationship between process and substance here?
Yeah, absolutely. I think I would echo really Annette's perspective here that they are inextricably linked. And even though you may have courts sometimes dealing with some of the underlying substantive issues, they will inevitably make their way as well into arbitration. I think that the drafting of an arbitration clause can, given the party consent that is necessary, can involve elements of sustainability in the procedure. So, parties could decide up front that they want to subject their arbitration to certain procedural elements that are that have a sustainable lens. But also in the subject matter, I think you see both in commercial arbitrations, but very much so in the investment treaty context, more and more intersection between ESG, environmental claims, climate change issues, pollution, environmental violations of environmental rights as they affect different populations. I mean, all of these issues are coming to the forefront in a lot of these contexts, particularly in the investment treaty context, where you see a lot of states now asserting counterclaims, actually. I mean, that's just one mechanism, but counterclaims which are seeking to enforce environmental rights. And you have a lot of bilateral investment treaties which actually now contain clauses dealing with both environmental but also social and governance elements, which ensure social justice being addressed directly within the treaty framework that is then applied to a particular dispute. So I think this is all so interconnected, and it will continue to intersect both between the procedure and the substantive evaluation of the dispute. And as much as possible, if parties think about these issues prior to the actual dispute arising, if they set those parameters ahead of time, either in their arbitration clause or in other parts of their contract, I think that can certainly make sure that the resolution of those disputes are done in a sustainable way. And as arbitrators are more conscious of these issues, I think they will also have that perception to be able to evaluate the disputes with a green lens involved.
Great, thank you, Brian.
Yeah, I think the only thing I would add, going back to the question of portions of the arbitral process that has a preference for outcomes related to carbon emissions. The only thing I will add, which kind of jumps off something Cherine had said earlier about hybrid hearings, where now because hearings, they do create such a carbon footprint footprint for all of those reasons that we've discussed, the travel, the printing. Now we're seeing companies decide that, okay, if we are going to do a hearing, it's going to be virtual by default. There has to be a good reason to be in person. But also, Freshfields released a top trends report for 2022. And one of the things that we predicted is that there is going to be more of this move to hybrid hearings. And then, within a dispute, each individual dispute, has its own characteristics and particularities. What the parties will decide, okay, what does hybrid mean, in that situation? But it will always include a virtual element, thus, helping to reduce that carbon footprint. And I know one hearing that I had scheduled where we were going to have all the lawyers and the tribunal in one room and all the experts and other witnesses remote. I think we might have had one witness be in person. So really, it depends on the party's consent, of course, and the particularities about or with respect to that case or that matter. But those hybrid hearings, like that is something that we really that's going to start to become the norm.
No, great. Yeah, I think that makes a lot of sense and is better. I guess we're running out of time for this part of the discussion, so I'll just ask one final question to all the panelists, which picks up on something Cherine mentioned just now, which is sort of what's the relationship between we're thinking about being more environmentally conscious in arbitration, but how do we balance that with the other social goals that should also be top of mind, like making the process more inclusive and things like that. So Cherine, if you want to pick that up.
Yeah, sure. Thank you. So I do think they are so very linked just by nature of, who will be most disparately impacted by the climate crisis. And we know that that's going to hit poorer and less developed communities the hardest. And speaking of the Caribbean, the launch of our Caribbean subcommittee, islands communities are particularly affected by these issues, and to the extent that we can relate those issues and kind of address them in a holistic perspective, I think they have more chance of success and more chance of really having a larger impact. One, actually, a colleague of mine on the campaign, Maguelone de Bruyère, she wrote an article. We wrote an article together about this particular issue of the interconnection between sustainability and, like, in the virtual world, how issues of discrimination and representation are affected by this move to the virtual context. And I think that applies also here as we're looking at the move towards trying to implement sustainability elements. The fact that there are a lot of parallels to be derived from cost savings and the move towards greener arbitrations, I think, is really a key element that that is important to highlight, because clients are very keen to implement these new behaviors if they then result in cost savings. Especially in a world where a client is hit by a dispute, and especially for smaller or mid-sized enterprises or companies dealing with disputes, they will be particularly sensitive to cost. So to the extent that you can kind of link the two issues together, I think that has a lot of resonance in that particular part of the business community. And then to the extent that you can also link with issues of representation, I think that's so important. And that's what I think the ESG movement has done in a general sense. There has been, of course, there is the potential for a lot of this activity to have a negative impact on certain communities. And that's why at the campaign, we've really tried to approach this topic from not a top-down perspective, but really from a kind of everyone coming from their own particular perspective. So that's why we have over 100 regional representatives from around the world that are committed to really pushing this forward in their particular regions and looking at this issue with the regional lens. So not only, implementing sustainable practices from one particular perspective, but really taking into account the specificities of the particular region in deciding how to address this topic and ensure that it really does get adopted, because that's the objective of all of us here, is making sure that these practices are adopted, and if they're not the best practices, finding out what the best practices are and learning from each other and not reinventing the wheel each time, but really contributing to a common effort towards encouraging the adoption of measures that are contributing to sustainability. And I'll just add one last note, which is that electronic acting, through electronic means, I think Annette alluded to this earlier, is not necessarily more sustainable. So there is a large electronic footprint which can be generated. So I think if you think about this in case management, I think there's a lot to be gained from the just streamlining of storage and not kind of duplicating files or using multiple servers and thinking about maybe a file management software. There are a lot of great tools out there to also minimize the electronic footprint as well, which is a crucial element that we need to take into account in engaging in these discussions. So I'll leave it there.
Great, yeah, thank you for pointing that out. Annette, do you want to share any thoughts on the relationship between sustainability and other goals?
Yes, I think Cherine was alluding to that. I mean, I can just concur what she said in terms of this is a tool for being more inclusive. And just to add a few examples. So when we learned a lot during the pandemic, clearly, when it comes to using the tools that were already out there in terms for digital tools, right? They were already out there. We weren't using them, and then we were forced to use them. And now finally we learned how to use them, which is brilliant. But what happened is that suddenly we were reaching out to places in the world and audiences where we previously had not had any contact, or where the people active there had not had a voice in our arena, international arbitration arena. So I think it became extremely inclusive, and I think that's something that we can maintain. So that sort of goes hand in hand in making it more inclusive, because these were constituencies and these were groups that would never hop on a plane and fly to Washington, D.C. to attend a seminar like this one, right? But now they are able to participate and have a voice in the conversation. So that's really a brilliant tool for both reducing footprints and having a voice. Having said that, though, I think what also became very clear that there's an issue here of due process and level playing fields when it comes to the technical infrastructure, and to having the energy, to having the technical tools, to having the connection that is stable, and all of these things and they could be frustrating when you are, of course, like in a seminar, but if you're in a hearing, it's crucial, right, that you are on the level playing fields. And I think that is something that quite early on that also received attention to. Yes, it is inclusive, but also you need to take this into account. So you do not put a technical expectation or the expectation on the standard of the technical issues involved that makes it non-inclusive, in fact, in the end. So that's something, I think the discussion was there quite early. So we just need to have that as part of the picture when we're talking about how this sort of green practice can also be more inclusive. So let's make sure that we are all abiding by standards that are available for everyone.
Great, thank you. Ryan, I'll give you the final word before we open up the floor to questions.
Yeah, I would only just add on that when it comes to this, our effort to make arbitration greener, there's definitely a nexus between the goal of also making international arbitration more diverse and inclusive as a practice area, as a legal field. And one nexus is through conferences and trainings, because what we have now are these conferences and trainings, which is capacity building, that have opened up way more than they ever were before, because before the pandemic, all of those conferences and trainings, or a lot, happened in person, and making it simply financially inaccessible, and physically inaccessible in terms of distance and time. Whereas now, there are conferences and trainings that you might have to pay for, but there are many more that are free now, that would be available to anybody, and that never would have been before. And so I think that kind of there's a nexus there, because now you've opened up the practice area a little bit more. You have, because of the medium, because of the virtual nature, people might be more comfortable. A younger practitioner, someone more newer, might be more comfortable asking a question in a chat than putting up their hand in front of a lot of senior people. So there's more inclusivity on that end as well.
Great, thank you. And I guess I'll pick up on that theme and say, now that the audience, if you'd like to ask a question, you can raise your hand and I'll call on you, and you can unmute and talk, or throw it in the chat, and I will read the question, and hopefully one of the panelists will be able to answer it for you. And if we don't have a lot of questions, I'd also encourage the panelists to ask each other a question if there's anything that you're curious about that you've heard about today.
Well, while the participants are thinking about which question to ask, I just want to sort of add another sort of thought when it comes to the networking and the way we're sort of expanding the network, and also the importance of the networking for capacity building and growing in the profession. And again, I think here is another example of it's not binary, right? So I think this past week's events have really illustrated, and then when I say past week's events, I mean, of course, the war in Ukraine has illustrated the importance of actually having a network where we not only have met over Zoom, although you could become friends of meeting over Zoom, but it is a difference from actually having met in person, having sat across a table, having talked about life, having sort of discussed not only the law, but other things, and become friends. Because that's what's in the international arbitration community. You have friends that, and where you share a sort of a common vision of the world. And the strength in that is absolutely fantastic. And again, I think what we have seen in terms of solidarity, in terms of people reaching out this past week, really illustrates how important that is. And it's a good thing for the world that exists. And we are not the only community, of course, building that, but we just happen to have the professionals as lawyers in international arbitration. So, and that's where we build it, and other communities build it elsewhere. But I think when we go forward, I think we will again need to find that balance. That yes, there will be opportunities or occasions when it will not be a good idea to travel, whereas others, yes, we should travel, and we just need to learn where to differentiate the one from the other to make sure that we do not lose the opportunity to continue building the strong network, because I do believe it's immensely important that we continue doing that.
Yeah, I think that's a great point, and definitely something I've thought about through my law school experience, where I'm trying to make connections and friends, and my whole second year was totally online and I didn't see anyone, and I feel like I missed out on that part of it, but I'm trying to make the most of it this year.
I think we have to recognize the fact that it's a different thing to be in the same room. We are human beings, and the energy that is created when we are in the same room and we sort of get to know each other that way is different than if you're from the screen. The screen is fantastic and can do a lot of things, but one does not exclude the other.
And I would just add on to that. There is what Annette was alluding to. There is an alchemy among humans when we're together, which we've lost that in the last couple of years, or those opportunities. And you can't, it's very difficult to replicate that human to human chemistry through Zoom. And when we had our workshop back in October, we had an international conference organizing expert speak to us about, okay, how should we envision conferences and trainings in the future and under the default of making them green. And he said, okay, 75% of conferences and trainings moving forward will likely be hybrid. So that means with an in-person element. And when it comes to that in-person element, it needs to be, you need to, as an organizer of the conference or training, articulate the why. Like, why are people getting together, and making it targeted, making it with intention, right? Rather than saying to people, okay, come for a few days, fly around the world, and then we throw you in a room and you're all supposed to just chat. One of the things he said moving forward that would be very beneficial is to look at, okay, how are you kind of curating that experience? But at the end of the day, I think it goes back to a lot of what Annette said, which is, we need, as humans, and professionals, we need that in-person human kind of interaction.
If I could just add one last point. Oh, sorry, I see a question in the chat. Maybe I can incorporate that. How can young practitioners convince older practitioners to go greener? And how can you win that battle when there's a big age difference? So yeah, I think I'll try to address both questions in my response. I just wanted to add it on the networking point that I think there is quite a lot also to be gained in the virtual setting. I'm definitely a proponent of interacting in person, and I think we can capitalize on the opportunity to do that locally. So there are a lot of amazing resources, especially, you being students in Washington, D.C., there are so many people that you can network with in the city. And true that there haven't been as many in-person events, but I think people are starving for more human interactions. So if you reach out to people, I think a lot of them are willing to accept a coffee or an outdoor, especially with the nice weather coming up, an outdoor, walk or just an opportunity to meet. But I think that also the virtual setting has allowed for people to actually interact, especially people who might not have had access previously, to gain that access and to actually get in touch with people who they might not have been able to get in access with previously. So I think that, I personally have had a number of conversations during this time where I was more, despite the busy schedule, more willing to give up, a half hour of my time while sitting at my desk between conference calls to be able to talk to a student or, a young professional very quickly in the course of my day than having to arrange for a lunch outside and meet them. And, so it was actually easier to build into my schedule than an in-person meeting. And I thought it was equally as fruitful in terms of the exchange and the amount of information shared and gains on both ends. So I think there are opportunities there. And in answer to the question in the chat, I would just say that I think that there is a little bit of a disconnect, but sometimes you'll be surprised that some of the older members are those who are open to change, and they just don't necessarily know the tools. And I think I'm maybe somewhere in that middle generation. I'll reveal my age. I'm 35, so I'm kind of like not in the young generation anymore, not in the older 50s plus generation, but somewhere in the middle where I have familiarity with technology, but not necessarily the most recent cutting edge technology. And I have the general disposition to want to move towards sustainability. And I think it's just, a question of having the right tools. So if you're able to share those tools with both the older and younger generation, which sometimes even makes their practice easier in a lot of senses, then I think they're quite open to making that transition. So I'll stop talking and turn it over to someone else.
I can jump in and just on the sort of convincing the older practitioners. I find in many conversations relating sort of taking initiatives on climate change related issues, talking to in the law firm setting or lawyer setting, I think referring to the client expectations is really a very winning argument, because many times the clients will actually be a step ahead because they are subjected to the market expectations. So they will be adopting, and they will have adopted protocols, and they will have this sort of procedures in place. And now clearly, then they would expect their advisors to have a similar standard. And if they don't, that could, in the end, in the long run, that would be a problem for the advisors. So if your firm is not there, I think pointing to the clients and the client's expectations should be enough to have the seniors listen to you.
Great. Yeah. I don't know, Ryan, if you want to chime in with anything else. This might be the end of the question period if there's nothing else. So.
Yeah, I think the only thing I would say in terms of bringing that up to maybe a more senior partner is framing it as a question. So rather than saying we should do this because this and this, you could kind of frame it as more have we thought about doing it this way because blah 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 blah. And listing those points, because then you're coming in with more of a kind of an open approach rather than giving off the impression that you're kind of dictating or you want to dictate that this is what should be done. So that I would just kind of give that little tip, which kind of builds off of both what Annette and Cherine were talking about in terms of how to kind of make that approach and ask that question.
I want to thank all the panelists again for this really insightful conversation, and I'd also like to thank the sponsors of this event. I think we have a slide that shows who they are. Okay, great. Yeah, so thanks for sponsoring us. Always nice to have sponsors. Without a lot of great groups here. Yeah.